Hello, I'm Karen Conti. I've been a practicing lawyer for over 25 years. Going through a bad marriage can be tough, but going through a divorce may be tougher. When everything that means anything to you is up in the air, your children, your home, your finances, it can be overwhelming. Knowing just a little bit about how the process works can help you take control, make plans, and hopefully come out in a good place. The first step in the divorce process is filing the petition for dissolution. The person filing is called the petitioner, and the spouse who's responding is called the respondent. Many people ask if it matters who files first, and the answer is no, not at all. The judge doesn't consider which party is seeking the divorce in making any of the decisions. The document itself, the petition for dissolution, provides basic information about the parties, the grounds or reasons for divorce, and also makes requests to the court for findings concerning children and money. The petition is filed in court, and that starts the process. Let's talk for a minute about grounds. There are two types of grounds for divorce: fault and no fault. In Illinois, no fault is what we refer to as irreconcilable differences. This merely means that you and your spouse don't get along anymore and nothing can be done to reconcile. Fault, on the other hand, is asserted by saying that your spouse was guilty of something such as mental or physical cruelty or adultery. In my view, you will almost always want to use no fault if possible. Why? It gets you divorced without you having to air your dirty laundry in what is a public document. Also, the whole divorce process can be very confrontational. Why start it off with derogatory statements if you don't have to? And finally, fault is not considered at all by the judge in making decisions as to who gets what. The only fault that would matter is one which affects the children and their interests. The second step after filing the petition for dissolution is to serve your spouse with a copy of the summons. This is usually done by a law enforcement official. If you can avoid serving your spouse officially, I believe that you should do that. Nobody wants to have a man in a uniform show up at their place of work. There are ways to serve the petition without this step. Ask your lawyer to explain your options. Once the spouse accepts the petition, he or she will be required to respond in writing to the petition, agreeing or disagreeing with what you've alleged. The third step is financial investigation, or what we call discovery. This process can be very tedious and expensive. It involves exchanging documents relating to your finances, such as tax returns, bank statements, credit cards, insurance policies, retirement accounts, and the like. The parties will send interrogatories, which are written questions to each other, to be answered under oath. This process is done to figure out what the assets, debts, and expenses are, and to prepare for either settlement or for trial. The fourth step is pretrial conference or settlement. Now, settlement can be done and discussed at any time during this process, but many times that doesn't really happen until all of the financial information is fully disclosed. Obviously, this is because the parties are entitled to know what each of them has before they agree to start dividing up assets and property. Now, settlement can be done in a number of ways. The parties can meet with their lawyers in a four-way conference and try to work out the issues. A mediator can be hired, an outside party who is trained to help you resolve your differences. And finally, a judge may agree to sit down with the parties or their lawyers and to try to facilitate negotiations. The last step in a divorce is trial. If you can't agree on all the issues, you have to be prepared to go to trial. If you agree to some issues, such as where the children will live, but not on how to split the assets, then the trial will address only those issues which remain unresolved. In a trial, there will be testimony by you and your spouse about the unresolved issues. The court will get to read all the documents that you tendered to them, and if necessary, other witnesses and experts will be called to testify about things such as the value of the property and perhaps the children's best psychological interests. Trial is expensive. Your lawyer has to prepare, and it's very costly. You'll be tied up in court for a number of days and will likely have to miss work. And the results are not necessarily predictable. It's often difficult for a judge to understand all of your family dynamics and finances and interests and to make the decision that you feel is the right one. The divorce process can be a long one. Be reasonable, be patient. Take control and understand what tasks are being performed and why. Cooperate with your lawyer. And most importantly, compromise if you can. If you'd like more information, please email me at the address on the screen, and I'd be happy to help you. Thanks for watching. I'm Karen Conti.